When does free speech become criminal conduct? Well, we may just find out from the United States Supreme Court. Alec Baldwin's charges are being dismissed for now. What happens when you become too lenient as a judge? You get transferred to the civil docket. Kim Potter, remember her? She's being released from prison. And when you say after your 9th DUI that you don't have a drinking problem, the jury will punish you. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, hit that little bell, and remember to leave me a comment below about what we talk about here today, or frankly, whatever's on your mind. And remember, you can listen to us on any of your favorite podcasting apps. Now, let's pay some bills. Let's go and support CrimeTalkSearch.com. When you go to that link, you'll be able to sign up for a background subscription service. When you do, you can do as many background searches as you desire while you have that service. And remember, whether you want to do one search or 300 searches, you can cancel at any time. But when you do the search, it is literally prepared while you wait, searching literally thousands of records across the United States, and a report is generated, and it's going to have everything that you want to know about someone. Things that they're not going to tell you. Are they a sex offender? Do they have criminal charges? Have they been accused of doing things to children? Maybe to women? Are they not nice people? Go look and find out. Go to CrimeTalkSearch.com. You'll be happy that you did. Now, quick update here. Lori Vallow, no trial today. They still got to, give everybody some time to do some other work, I guess. That's okay. It's normal. Letitia Stout, they are just piling on right now. It was so bad today. At one point, she had her head down on the table. I wonder what the jury's thinking at this point. Maybe it's finally starting to hit home that she's probably going to go to prison for the rest of her life. Anyway, check it out. It's streaming live. And remember, we have all of the trial testimony up for the Lori Vallow trial. So go binge watch or listen over the weekend if you haven't listened to it already. All right, let's go ahead and open the record for April 21st, 2023. And let's begin our docket. When does free speech become criminal conduct? Like I said, we may find out from the United States Supreme Court, and it just happens to be in regards to a Colorado case. Now, the Colorado legislature has a way of always drafting poorly written statutes, and that is why, they're found to be unconstitutional all the time. There's this case called Washington v. Crawford, which basically said, you can't let people testify, even though if you think it's reliable testimony and they have to be subject to cross-examination. Not only did they swat down the Washington state statute in that particular court case, they also took aim at Colorado because they basically allowed anything to come in from anybody as long as the court found that it was reliable. And the legislature here and the courts in Colorado have said, basically go along, as long as we get the bad guy, isn't that all that really matters? Well, there's that pesky little thing called the First Amendment, right? Remember, you don't have a right not to be offended, and the government can't infringe upon your free speech. And they certainly are infringing on your free speech if they impose a criminal sanction. So, the Supreme Court of the United States heard oral arguments this past Wednesday regarding the case of a Colorado man who was sentenced to 4.5 years in prison based upon stalking, based upon, guess what? Some Facebook messages that he sent to a local musician. At issue in this case is how the court should determine what constitutes a true threat, which are not protected by the First Amendment. And at the end of the nearly 2-hour hearing, the Supreme Court justices appeared a little skeptical as it relates to Colorado's contention that the court should use an objective standard test to determine whether a reasonable person would regard the statement as a threat of violence. But it's not exactly clear what test, if any, the Supreme Court might adopt. So the attorneys representing the petitioner, the convicted guy in this case, a guy by the name of Billy Raymond Counterman, his attorneys argued to the court that they should shun the objective test on which the state court relied to convict his client. He emphasized the negative effects that would flow from such a test, noting that criminalizing misunderstandings, well, that's dangerous in an age when communication occurs on social media, which brings together strangers, an environment that removes much of the context that gives the words meaning. The objective test, the attorney argued, would also chill even legal speech because speakers will not want to risk prison time if their speech is perceived as a threat. Think about that, ladies and gentlemen. An objective test. What would a reasonable person think? Well, guess what? A reasonable person standard is a negligence standard, which is normally reserved for the criminal courts. Normally in criminal courts, we have to show specific intent. What was the intent of the individual thinking at the time? Why is this a big issue? Well, the federal courts have basically said that a true threat is something that the prosecution must show, and I'm simplifying it here, but basically so that it was the defendant's intent to cause fear, and he knew that what he was doing was going to cause fear. Think about that. In today's world, how many people are offended in so many ways where anybody could say, oh my gosh, you said something that hurt my feeling, and I took it as a threat. Yes. So if you have an objective standard, that's tough. You have to show that the person intended to do that under the federal law. And so the Attorney General here in the state of Colorado, who prior to becoming the Attorney General, I think was briefly a U.S. attorney and has never tried a case as a prosecutor or as a defense attorney. He's tried one case, I think, as he worked in the antitrust case. So when he was like one of 50 people in the antitrust division of the Department of Justice, and then he was a law professor. Yeah. Anyway, we'll just leave it at that. Phil Weiser, the Attorney General, because, you know, you're going to Supreme Court, you got to have the Attorney General show up. And he countered that adopting Mr. Counterman's subjective intent standard would enable more harm and less valuable discourse because a serious expression of an intent to cause unlawful physical violence directly causes life-changing harm. He argued that it does not contribute to the marketplace of ideas. In particular, Attorney General Weiser stressed, requiring specific intent in cases of threatening stalkers would immunize stalkers who are untethered from reality and allow devious stalkers to escape accountability by insisting that they meant nothing by their harmful statements. This matter, Weiser continued, because this matters, Weisner argued, and he continued by saying threats made by stalkers terrorize victims. So there's the argument that's set. Now, Justice Alito tried to clarify exactly what rule the petitioner, Mr. Counterman, was proposing, and Mr. Counterman's attorneys responded that under his rule, a speaker could be convicted if he had knowledge of the thing that makes the conduct wrongful. In most threat statutes, that knowledge is that the words you use are going to cause fear. And for the Colorado stalking law at issue in this case, the attorney said it would be knowledge that it would cause a reasonable person to suffer emotional distress. Now, Justice Alito suggested that a different standard, more stringent than Colorado, but a lower bar than Mr. Counterman might argue would possibly be appropriate. And the judge questioned, why should the test be whether the speaker's conduct was reckless? That is, he was aware that others would regard his speech as a threat, but he made the statements anyway? Reckless conduct, the justice asked. He says, is morally culpable and a threat causes damage regardless of the intent of the speaker? A reckless standard would be a big improvement over an objective standard, Mr. Counterman's attorney noted, because it focuses on the speaker and his mental state and is therefore less likely to chill speech than a purely objective standard. But there's no tradition in U.S. law of regulating threat based on recklessness, the attorney argued. And that's significant because the courts have often gone through a historical analysis as to what the law should be, because obviously the law needs to be interpreted under federal law and the Constitution at the time that it was written. Now, Justice Kavanaugh also seemed amenable to a reckless standard, and he told the Attorney General that it seems to capture some of the concerns you've heard while leaving plenty of room, one would hope, to make sure that the threats capture before someone is killed or physically hurt. Now, Chief Justice Roberts worried aloud that adopting Counterman's rule would make it harder for domestic violence victims to obtain civil protection orders, which often require proof of a crime. Justice Thomas was also troubled by the idea. He told Attorney General Weiser, "We're more hypersensitive about different things now, and people could feel threatened in different ways." Some of those statements that Justice Roberts had pointed to, Thomas said, are not threatening of themselves. And yet someone could be triggered by those statements or hypersensitive about those statements and feel threatened. Justice Amy Coney Barrett had a related concern when she said, "Who," she asked, "is the reasonable person?" She outlined a hypothetical involving a college classroom in which a professor, for purely educational purposes, put up a picture of a burning cross and read aloud some threats of lynching that were made at the time. Maybe it's the case, Barrett suggested, that nowadays people would be more sensitive to that, and a reasonable black college student sitting in that classroom would interpret that as threats that might materialize into actual physical harm. Now, representing the federal government was Deputy Solicitor General Eric Fagan, and he cautioned that a focus on the defendant's specific intent makes it much harder for prosecutors to arrest and bring charges. The Supreme Court's actually reversed cases where someone was charged with basically harassing conduct on the internet. So we'll have to wait and see how the court comes out on that case. But kind of along the free speech line is we have a case that will more than likely make it to the Supreme Court. And that was a case involving Douglas Mackey, also known as Ricky Vaughn on Twitter. That was his handle. And he was found guilty of charges of election interference by a federal court in the Eastern District of New York. Now, the charges stem from a meme that Mackey posted on Twitter in 2016, jokingly, according to him, encouraged supporters of Hillary Clinton to vote by text. Now, the Justice Department alleged that this constituted election interference, despite being unable to provide evidence that anyone actually was deceived by the meme. Mr. Mackey argued that he was simply trying to create a viral meme and that other Clinton supporters had posted similar memes encouraging Trump supporters to vote by text without consequence. Federal prosecutors, however, claimed that Mr. Mackey worked with a fellow meme maker to create the Twitter post and make them as real as possible. The United States Attorney said this wasn't about changing votes. This was about vaporizing votes, making them disappear. So that was the U.S. Attorney there, Turner Buford. He says that the number was real and set up to receive incoming messages. And the release of these fake campaign ads was timed to flood the internet right before Election Day. Mr. Mackey posted the memes on November 1st, a week before the election, and the attorneys for him argued that the message in the meme was ludicrous to anyone with any simple, basic knowledge of how presidential elections work. Well, he faces up to 20 years in prison. Really prosecuted that. Maybe if the Babylonian Bee or the Onion had done it, it would be okay. Next, the Supreme Court also has accepted a case involving a tongue-in-cheek dog chew toy made to resemble a Jack Daniel's whiskey bottle. VIP prevailed in defending the toy as protected speech, but the distiller wants the Supreme Court to declare such parodies to be trademark violations. Another pending case is Novak v. City of Pharma, in which Anthony Novak was prosecuted for posting a parody of a website of his local police department. He was charged with and later acquitted of a felony under an Ohio law prohibiting the use of a computer to disrupt or interrupt police functions. Now, the satirical site The Onion has filed a parody brief to support the right to parody. The Onion regularly publishes funny fake news stories and true to form, filed a brief as the self-described world's leading news publication, offering universally revered coverage and noting it is the single most powerful and influential organization in human history. It told the court that it has more than 350,000 full and part-time staff members and are renowned for maintaining a towering standard of excellence in journalism. It added that it owns and operates the majority of the world's transoceanic shipping lanes, stands on the nation's leading edge of matters of deforestation and strip mining, and proudly conducts tests of millions of animals daily. It was a tour de force on the value of satire to make profound legal and political points. The court has yet to decide whether to take the Novak case, but it has accepted the Jack Daniels distiller case, and the distiller there sued VIP over its introduction of the Silly Squeakers, Bad Spaniel's rubber squeaky toy. The toy is shaped like a whiskey bottle with a cartoon spaniel on the front of it with the caption, Bad Spaniels, the old number 2 on your Tennessee carpet. A small disclaimer is on the back. The product is not affiliated with Jack Daniels Distillery. That clearly was not enough for the distillery, which argued that people would be confused by the parody. While the district court originally ruled that Jack Daniels was correct, it was reversed by the U.S. Court of Appeals for the Ninth Circuit, and the chew toy was ruled correctly involving the new expressive conduct. That's in my mind. Anyway, the Supreme Court has recognized that satire and parody have long played a key role in political discourse, stretching back to ancient Greece. In 1988, the court handed down the important free speech decision in Hustler magazine v. Falwell, holding that offensive cartoons of Reverend Jerry Falwell was protected under the First Amendment from civil liability. We'll have to see, ladies and gentlemen. These are different times indeed, where free speech seems to be on the attack. Be informed. And just because you don't like what somebody says, well, guess what? In a free society, you got to do that, because guess what? What you're saying may offend somebody else. And if you send them a tweet or a text message or a comment saying that you're being rude and you're triggering them, do you want to be criminally charged for that? Something to think about. Next on the docket, Alec Baldwin. Charges being dismissed for now, according to the prosecutor. That's right. Alec Baldwin could face new charges in the fatal shooting of the camera woman on the Western film set of Rust. Prosecutors in New Mexico have warned hours after the criminal manslaughter charges were dismissed. The special prosecutor appointed to the case stressed on Thursday evening that Mr. Baldwin has not been cleared. Their statement came shortly after Baldwin's lawyer said that their client was pleased, and the actor posted a tribute to his wife on his Instagram, thanking her for all of her support over the long 18 months. Now, the prosecutor issued a statement saying this decision does not absolve Mr. Baldwin of criminal culpability and charges may be refiled. Mr. Baldwin had insisted that he did not pull the trigger on the prop gun when it fired back in October of 21, ultimately killing Helena Hutchins. The FBI said that that theory was impossible. However, charges were dropped on Thursday because new evidence showed that the gun could indeed have fired without the trigger being pulled. And the prosecutors confirmed they have obtained new facts about the circumstances around the shooting, which led them to dismiss the existing charges against Mr. Baldwin. Now, the armorer who provided the prop gun to Mr. Baldwin, Hannah Gutierrez-Reed, is still being prosecuted as planned. And over the last few days and in preparation for the May 3rd preliminary hearing, new facts were revealed that demanded further investigation and forensic analysis in this case against Alec Baldwin. That's the official statement from the special prosecutor. Consequently, we cannot proceed under the current time constraints on the facts and the evidence turned over by law enforcement in its existing form. We therefore will be dismissing the involuntary manslaughter charges against Mr. Baldwin to conduct further investigation. Like I said, the prosecutor says it doesn't absolve Mr. Baldwin of culpability and charges may be refiled. Our follow-up investigation will remain active and ongoing. Charges against Hannah Gutierrez-Reed remain unchanged. So what does that really mean? Boy, could the prosecutors in New Mexico look a little more incompetent? I'm not sure it really goes that way. Remember, one prosecutor resigned. The other one that was the former prosecutor became an elected official and basically got kicked off the case. The prosecutor that was handling the case that filed the charges, she appointed a special prosecutor. The special prosecutor has the case for less than 2 weeks, and all of a sudden, charges get dismissed based upon some new evidence. It's unclear whether it came from Mr. Baldwin's camp or whether it was their own firearm experts. Now, remember, the FBI had this gun for 18 months before they charged it, and now they just happen to figure out that it can go off randomly? What are you doing down there, New Mexico prosecutors? Really? Get your act together. So instead of looking embarrassed and possibly losing in court, the prosecutor dismissed the charges against Mr. Baldwin. And of course, statute of limitations still run. So as long as they charge Mr. Baldwin within the applicable statute of limitation, he can still be charged. Jeopardy would not have attached because he has not entered a plea or a jury has not been seated in his case. Therefore, we'll see if they get their act together down there. Next on the docket, what happens when you're a lenient judge on crime? Even in New York City, that's right, you get transferred to the civil division. So after some intense criticism over her rulings, a Bronx judge who let free a teenage gang member that shot an NYPD officer has been removed from the criminal bench. According to the city, the Supreme Court Justice, Neda Sema, is expected to make the silent transfer from criminal to civil courts after tomorrow. Now, Sema, and you have to remember, a Supreme Court Justice in New York is the trial level. It's the trial court judge, okay? Trial court, then you have the appellate courts, but they call them Supreme Court Justices. They're not. Anywhere else, that's completely wrong. Leave it to New York to do everything opposite. Anyway, Sema has received a little bit of backlash, not only from government officials and law enforcement for her leniency in court case rulings. This includes when she dropped charges against a 16-year-old Carmen Williams, an NYC rapper accused of shooting an NYPD officer, Kasim Pennant, in the leg back in January of 2022 as he was being searched. Police say that Sema has a history of going easy on teen offenders and says her interpretation of the Williams arrest was entirely wrong. When the rapper's charges were dropped, Sema argued that the prosecutors failed to show that Pennant suffered significant physical injury despite being shot. That's a stretch, but okay, Judge. Anyway, Williams fought with the police officers in January when they responded to reports of unrest, and he refused to comply with the officers' orders, specifically to remove his hands from his pockets. He began fighting with one of the officers, and during the tussle, the gun went off, and a single bullet struck the wounded Pennant, the police officer, and hit Williams in the groin. Now, Sema took over the handling of juvenile cases from her other colleague, Justice Dennis Boyle, last January, and Boyle had sparked widespread outrage by allowing teenage suspects accused of serious crime to be released on bail. Now, her first few weeks presiding over the juvenile cases, Sema has shown herself to be just as lenient as her predecessor by allowing two 17-year-olds facing felony charges to walk free. Braulio Garcia was arrested in January on charges of murder, manslaughter, robbery, and gang assault in connections with the death of a Good Samaritan, a guy by the name of Roland Houston, who was struck by a train while trying to save another man from the tracks. Prosecutors had asked that Garcia be held on bail, but Sema ordered him to be released with supervision a month later. Sharif Mitchell faced attempted murder charges for allegedly opening fire on a subway platform and shooting a 19-year-old man 4 times. Sema released Mr. Mitchell on his own recognizance, even though another judge had ordered him held on a $30,000 bond after his arraignment. Sema is a native of New York but grew up in Jamaica. She returned to New York to attend the Lehman College with a degree in social work, which explains so much. After working for a foster care agency, she continued her education and ultimately went to law school at the St. John's University of Law. After graduating, she was hired as an administrator for the Child Services Attorney and later became a court attorney with New York State Unified Court System back in 2010. In 2018, Semo won a seat on the bench in the New York Civil Court, and last November successfully ran for election for judge of the Bronx Supreme Court. She went on to serve in her current position in 2022. I don't know, ladies and gentlemen. If it's a violent crime, most people say you stay in custody. Just the way it is. I don't care if you're a juvenile, an adult. That's just the general rule. Next on the docket, remember Kim Potter, the former police officer who killed Dante Wright when she mistook her taser for her gun? Well, she's being released from prison after serving 16 months in the old big house. Now, Potter served her sentence at the Minnesota Correctional Facility and will serve another 8 months on probation beginning on Monday. You can tell by some recent mug shots that she's looking a little frail and a little thinner than she was a year after she was sobbing at her sentencing back in April of 2020. Now, she was a 26-year veteran of the police force and claimed that she obviously accidentally shot Mr. Wright when she reached for her gun instead of her taser at a traffic stop over his expired license plates. Now, Potter, who was convicted of first and second-degree manslaughter back in February of 2022, received a sentence that was way below the guidelines, which called for a 7-year and between a 7 and 15-year maximum sentence in Minnesota for the first-degree manslaughter. Potter and other cops had pulled Wright over for driving with an expired license tag, and there was a warrant out for his arrest at the time, and he tried to drive away from them, which is why Potter reached for her taser. In body cam footage, though, Potter can be heard repeatedly shouting, "I'll tase you, taser, taser, taser." But moments later, she then fired a round and immediately said, "I grabbed the wrong effing gun." Potter can then be seen collapsing to the curb in despair, saying, "I shot him, oh my God." Now, during Potter's sentencing, Judge Regina Chu took pity on the former officer, noting her guilt and referring to the shooting as an accident. Potter's clean background also resulted in the lower prison sentence actually, and since she never intended to hurt anyone, her conduct cries out for a sentence significantly below the guidelines the judge made in her sentencing statement. Well, we wish the former officer well, and at least we know she won't be handling weapons anymore because, well, she's a felon. She can't do that anymore. Next on the docket, when you have your 9th DUI and you think you don't have a drinking problem, guess what? The jury is going to punish you. Please meet Christopher Farnan Stanford. He was given a life sentence in prison after receiving his 9th DWI charge, claiming he was simply unlucky rather than irresponsible for repeatedly driving under the influence. Now, the driver pled guilty to the felony charge and was handed the life term by a Parker County jury. So in Texas, the jury can do the sentencing. Anyway, Mr. Stanford repeatedly opted for the jury to decide his fate and not the judge. His record showed that he was going to continue endangering communities throughout the Metroplex unless he was locked up, is the argument that the Parker County DA, Jeffrey Swain, made to the jury. And since Mr. Stanford had 4 previous prison sentences for felony DWI offenses, he was treated as a habitual offender. Now, Mr. Stanford's latest DUI charges came when his ill-conceived plan to flee on foot after running a red light caused an accident back on August 15th of last year. When firefighters and police arrived, Mr. Stanford's Lincoln MKC was discovered to have run the red light. The victim of Mr. Stanford's botched hit and run claimed the 50-year-old told him, "I have to go. I'm going to get in trouble." Shortly after that, they found Mr. Stanford attempting to escape by climbing over a barbed wire fence. You must be pretty desperate and want to get away if you're going to try to scale some barbed wire. Anyway, after police caught up with him, Mr. Stanford reportedly registered a .267 blood alcohol content. Remember, the legal limit for Texas is, like everyone else in the world, .08. So that's 3 times the legal limit. Now, one DUI charge in the state of Texas can land anyone for up to 2 to 10 years in prison, in addition to the loss of a driver's license for 2 years. And a person in the U.S. can be charged and convicted of a first-degree DWI if they had 3 prior DWIs within the last 10 years. Stanford reportedly denied having a drinking problem when he addressed the jury, claiming he just happened to be very unlucky. Now, under Texas law, Mr. Stanford will be eligible for parole when his actual time served plus his good time credit totals 15 years. I'm telling you, juries are smart. They don't like to be BS'd. And I'm telling you, I've told lots of people over the years, you get a DWI, DUI, whatever they call it in your jurisdiction. The first one can happen to anybody. A second one, you got to start thinking. You get a third, you've got a problem. Anything after that, you're a raging alcoholic. You are a danger to the community. And juries recognize that. And that's why Mr. Stanford, well, he's going to prison for a long time. He'll be drinking prison hooch, not anything from the local liquor store anytime soon. I guess that's one way to sober up. And yes, guess what? That was not our dumb criminal of the day. Meet Jordan McCulley. Police say that the vacationing McCulley broke a window and entered a property in Clearwater, Florida, which was not open to the public. When the cleaning crew members confronted him, police say McCulley said, "I'm leaving," and walked out the property's front door. Well, McCulley exited with a trash bag of alcohol bottles in his right hand and a fire extinguisher in his left hand, according to the criminal complaint and the affidavit for the arrest warrant. Needless to say, guess what? Mr. McCulley had the indicia of alcohol when he was arrested. Now, Mr. McCulley was arrested about 12:30 a.m. and charged with burglary and grand theft. Both are felonies. That's one way to spend vacation. And he was booked into the county jail where he's locked up on a $20,000 bond. He's also being held on a felony arrest warrant for failing to show earlier this month at a Minnesota court hearing in connection with a recent arrest for allegedly stealing a pair of laptops from the Best Buy. After being advised of his Miranda rights, Mr. McCulley allegedly told the police that he made some incriminating statements, including a request that he should only be charged with the lesser crime of vandalism. He also declared it's a fun time to drink and to have a fire extinguisher. Court documents do not indicate what plans Mr. McCulley had for the fire extinguisher, but they likely would have added to a rap sheet that already includes convictions for assault, property damage, fleeing police, theft, forgery, fraud, DWI, false imprisonment, making terroristic threats, assaulting a peace officer, escape from custody, robbery, domestic abuse, and disorderly conduct. I would bet you that maybe Mr. McCulley has a alcohol problem as well. Just saying. Anyway, simple rules, ladies and gentlemen. Don't take other people's things. Don't go into other people's property. It's a crime. Mr. McCulley, congratulations, you made it. The fire extinguisher was a nice touch. I'm not going to lie. Nice touch. You're a dumb criminal of the day. All right, thanks for watching. Have a wonderful day. We'll see you next time on Crime Talk.